Weiss'Sconcise Trustee Handbook, blank, a guide to the administration of an express trust under the common law, functioning under the general law merchant. By Carlton Albert Weiss, 2D edition 2008. Weiss'Sconcise Trustee Handbook, a guide to the administration of an express trust under the common law, functioning under the general law merchant. By Carlton A. Weiss, 2D edition. 2008. Enlarged and revised. Copyright 2005-8 by NACRS. All rights reserved. For private educational use only. This book is published with the understanding that the author and publisher, jointly and severally, are not engaged in rendering legal, accounting, or other professional advice. All decisions made based on the material in this book are ultimately done at the discretion of the reader. Author and publisher, jointly and severally, assume no liability whatever. Published by Negotiations Analysis and Contractual Relations. Specialists NACRS in care of GOLDE and POWERSC 1930 Village Center Circle, Suite 3-213. Las Vegas, Nevada 89134. Email, contact us at nacrs.org. Telephone, 702-357-8830. http://www.nacrs.org. Contents. Express Trust vs. Corporation page 17. Sample Forms page 45. Authorized Representatives page 16. Conclusion page 43. Privileges and Liabilities of the Trustee page 13. Maintaining Proper IRS Relations page 41. Powers and Duties of the Trustee page 11. Prevailing in Legal Affairs page 34. Trustee Basics page 10. Keeping Minutes page 34. Certificates page 8. Issuing Certificates and Bonds page 32. The Trust Corpus page 6. Transferring Assets page 29. Declaration of the Express Trust page 4. Banking page 27. Express Trusts under the Common Law page 2. Limiting Liability and Risk page 26. Trust Basics page 2. Doing Business page 24. Introduction page 1. Understanding Commerce page 21. Introduction. This handbook is about the administration of express trusts created under the original American common law and functioning within the unique system of commerce in the American states, i.e., the general law merchant, one as it stands in 21st century America. The material presented herein has been reduced from various sources which the reader is encouraged to examine for his own knowledge and further understanding. The material herein has been rendered into a concise handbook format, intended to allow the reader to refer to each section for guidance on decisions regarding the most pertinent aspects of the administration of an express trust. So, only secondary attention has been given to all other matters. All in all, the author's objective by this handbook is to devise a simple guide, with clearly outlined methods and sample forms, for the effective handling of affairs of express trusts, while also showing the many options for growth and prosperity, and profound protections afforded by express trusts when created and administered properly. This book is written in a somewhat unconventional manner in order to accommodate this objective. If the reader should find, after examining the sources, that this work has failed in its objective, then let it be attributed to a fault of the author, not to any supposed faultiness of the sources or the express trust itself. It will be admitted by all honest and learned lawyers, as it once was when a lawyer, by definition, was learned in the law. 3. Weiss'Sconcise Trustee Handbook 1. 2. It was the strongly held belief of U.S. Supreme Court Chief Justice Warren E. Burger that 75 to 90% of all trial lawyers are either incompetent, dishonest, or both. See 102 Reports of the American Bar Association, 205 to 206, 1978. 1. The general law merchant is embraced under general common law, i.e., the original and unique system of commercial law in the American states, in which there is no commerce regulation of express trusts except in connection with income derived from corporate stock and physical franchises under Art. I. Section 8, CL 1 and 3 of the Constitution. C. William A. Fletcher, The General Common Law, and Section 34 of the Judiciary Act of 1789, The Example of Marine Insurance, 97 Harv. L. Rev. 1513, 1514, 1984. That the express trust, especially one created with proper care to its instruments, is a far superior form of security, or organization in general, for individuals who desire to exercise their natural rights. Trust basics. First, it must be understood that any trust, regardless of the many designations applied to them, is, in its most basic sense, a property interest held by one person, the trustee, at the request of another, the settlor, for the benefit of a third party, the beneficiary. For the classification applied to a trust is based primarily upon its mode of creation, in which it may be created either by act of a party or by operation of the law. In the case of the former, trusts are divided into two types, express or implied. Without getting into the various subclasses of express and implied trusts, the basic difference between one created by express act of a party and one created by implied act of a party is that the former is stated fully in language, oral or written, while the latter is inferred solely from the conduct of the parties. These are very generalized definitions presented for want of space, since there are many intricacies concerning the true meaning of the term implied. It has been shown that, in a sense, the classification of express trust can only be applied based on what is implied by the language of the instrument which created the trust. 5. So, we won't get into that. Our focus is on a particular written express trust type, and even though the above definition is essentially accurate, it does little to define the express trust as it is known in its fullest sense under the protections of the common law. Express trusts under the common law. The most adequate definition of the express trust is to be understood from the earlier case law, which has been eloquently summed up and restated into a clear, concise. 2. Weiss'Sconcise Trustee Handbook. Creating a trust. By ACT of a party. Implied express. Resulting constructive. Oral written. By ACT of the law. 5. C. George P. Costigan Jr., Classification of Trusts, 27 Harv. L. Rev. 437, 438-439, 1914. 4. Black's Law Dictionary, page 1513, 7th ed. 1999. An even more basic definition is provided therein as, t.e. right, enforceable solely in equity, to the beneficial enjoyment of property to which another person holds the legal title. There are many more sub-definitions, as well as expansions upon the nature of a trust relationship, being a fiduciary one, but we won't get into them for want of space. 3. Black's Law Dictionary, page 695, 1st ed. 1891, definition by Alfred D. Chandler, Esc.6 in a report submitted to the Tax Commissioners of Massachusetts on unincorporated associations. 7 His study was conducted as part of a legislative investigation into their economic effect on the state in 1911. In the first part of the report, at pages 6-7, he offers the following definition. Express trusts put the legal estate entirely in one or more persons, while others have a beneficial interest in and out of same, but are neither partners nor agents. This simple, adequate, common law right, any person or group of persons sui juris the 8th of May exercise, the trustees issuing certificates of beneficial and capital interest divided into shares, as well as issuing bonds and other obligations, as freely as they open a bank account, have a pass-book, and draw and circulate checks, or make whatever contractual relations are allowed to persons as a natural right. Italics emphasis supplied in original, bold emphasis and bracket information added. What becomes clear from this definition is that the express trust is not merely a property interest held by one for the benefit of another like any basic trust. Rather, it is a trust created by private contract for the holding of a divisible property interest wherein the trustee is empowered by the settlor to do for a beneficiary of his the trustee's choosing whatever he may do for himself as an individual sui juris. 9. What has been created here as a trust organization, lawfully, by natural right. As a general proposition, it may be asserted that one who creates a trust may mold it into whatever form he pleases, and that whatever one may lawfully do himself he may authorize another to do for him. 10. Doing so requires no benefit, privilege or franchise from any government or other outside party. 11. Therefore the parties owe no duty to any government or other outside party to the extent that no common law criminal or civil wrong is the purpose of. Weiss'Sconcise Trustee Handbook 3. 11 C. Hale v. Henkel, 201 U.S. 43, 74 1906. 10 HARWOODV. Tracy, 118 Mo 631, 24 SW 214, 216. See also Shaw v. Payne, 12 Mass. 293. A person who creates a trust may mold it into whatever form he pleases. Perry on Trusts, I, Section 67, 287, 4th Amer. Ed. Underhill on Trusts, page 57, Amer. Ed. 9 C. Pres. Woodrow Wilson's address before the American Bar Association, at Chattanooga, Tennessee. August 31, 1910, entitled The Lawyer and the Community. He says, liberty is always personal, never aggregate, always a thing inhering in individuals taken singly, never in groups or corporations or communities. The individual unit of society is the individual. It has long been held that trustees of express trusts have greater latitude than ordinary trustees, simply because such trusts, created by individual sui juris, may do whatever individual sui juris may do. 8. This is defined as, of his own right, not under any legal disability, or the power of another or guardianship. Having capacity to manage one's own affairs, not under legal disability to act for oneself. Black's Law Dictionary, page 1135, 1st ed. 1891. 7. Mr. Chandler lucidly brought to the attention of the Massachusetts Tax Commission the misapplication of the term voluntary association to the express trust. It is well settled that the term, association, for income tax purposes taxable as a corporation, embraces business trusts, and what Congress did not intend to embrace within the term association was a pure express trust, that is a trust of traditional pattern where property is conveyed by will, deed, or declaration to a trustee. Pennsylvania Co. For insurance on lives and granting annuities v. U.S. 138 F.2d 869 CCA 3 Pa 1943. In Crocker v. Malley, 249 U.S. 223, 63 L. ed. 573 1919, the court made it clear that a pure express trust, active and functioning as such, has standing in law as a trust, not an association. 6. Express trusts under the common law, a superior and distinct mode of administration, distinguished from partnerships, contrasted with corporations. 1912. The contract. 12. When done properly, the trust is afforded all the common law protections ordinarily given to private contracts, particularly the obligation of them. 13. Now, the question is whether the parties to the contract are truly acting sui juris, i.e., of their pure, unadulterated common law natural rights, because if the parties import or associate benefits which grant an outside party a vested interest in the proposed contract, then the contract has acquired a third-party overseer intervenor. 14. Declaration of the Express Trust. The Declaration of Trust 15 is the trust instrument that constitutes the trust. It has been noted in trust law that no technical expressions are required to create a valid declaration, so long as the words used make clear the settler's intent to create the trust or confer a benefit of some sort that would be best carried out in the form of a trust. 16. A trust instrument doesn't necessarily need to be a declaration either, for a trust may be, and often is, formed out of a simple agreement or even a will. 17. But with an express trust, the declaration has been preferred since the beginnings of trusts under the common law of England, which otherwise shunned fictions of law. This is where careful attention to detail is most crucial, because in order to properly construe the intent of the settlor, the objects, property, and manner in which all is to be carried out must be set forth in unambiguous, precise language so as to particularly create the express trust, and where the intent of the settlor is unclear, under equity, interpretation is required to construe the intent of the parties, and the trust may be deemed invalid, depending on 4 Weiss'Sconcise Trustee Handbook. 17 Underhill on Trusts, Art. 5, page 19, Lond. ed. 1878. 16 C. Underhill, Supra Art. 3, page 10, see also Chicago M. NST. P.R. Colorado v. Des Moines Union R. CO. 254 U.S. 196, 65 L. ed. 219, 1920. 15 This is sometimes referred to as the trust indenture for the purpose of denoting that it outlines the terms and conditions governing the conduct of the trustee as an indentured servant to the beneficiary under contractual arrangement, referred to in this sense as an indentured trustee. 14 C. Lee Brobst et al., USA. The Republic is the house that no one lives in, available at http://www.usa-the-republic.com/Lee% 20 Brobst/usa.html last visited Jan. 8, 2007. 13 In Berry v. McCourt, 204 NE 2D 235, 240 1965, the court held that the express trust is a contractual relationship based on trust form, and in Smith v. Morse, 2 Cal. 524, it was held that any law or procedure in its operation denying or obstructing contract rights impairs the contractual obligation and is, therefore, violative of Article 1, Section 10 of the Constitution. Because the express trust is created by the exercise of the natural right to contract, which cannot be abridged, the agreement, when executed, becomes protected under federally enforceable right of contract law and not under laws passed by any of the several state legislatures. In Elliott v. Freeman, 220 U.S. 178 1911, the court made it clear that the express trust is not subject to legislative control. It went further to acknowledge the right-wise stance of the United States Supreme Court that the trust relationship comes under the realm of equity, based upon the common law right of contract, and is not subject to legislative restrictions as are corporations and other organizations created by legislative authority. To clarify the equity and common law distinctions, the basis for express trusts under the common law in this instance is not that such organizations are creatures of common law, as distinguished from equity, but that they are created under the common law of contracts and do not depend upon any statute. 12 Lawson on Contract Section 294, page 381, 3d ed. 1923, the degree of ambiguity. 18 However, when all is done properly, obviously, there can be no lawful impairment of the obligations of contract. 19 Moreover, the declaration, by its terms and provisions, serves to establish the entire contractual arrangement, including the identities and positions of the parties, the trust's name, jurisdiction and situs, and all particulars of administration, all of which the courts of equity will fully support by the principle that equity compels performance. 20 The ultimate result is the creation of a bona fide legal entity. 21 With its own separate and distinct juridical personality. 22 With standing to sue and be sued. 23 And to function as a person in commerce by and through its trustees. The term natural person has been applied to express trusts by courts of equity because of its administration, being carried out by men acting as natural persons. 24 Under this application, the trust's right of Weiss'Sconcise Trustee Handbook 5. 24 A generally unknown fact is that there are several types of citizens now existing in America. The trustees of an express trust may seek protection under the constitutions as state citizens throughout the Union of States, a jurisdiction outside the scope of the 14th Amendment, which we will discuss in a later section. However, it should also be noted of all citizenship, 14th Amendment or otherwise, that jurisdiction over natural and artificial persons is distinguished without a fundamental difference. This stems, surprisingly, from the operation of in rem jurisdiction which underlies all civil law. Though all courts are familiar with the action in personam against persons, it is the action in rem against things which, though practiced only in maritime law, stealthily operates in every civil and criminal court. This principle is one of the least understood in its entirety. In rem jurisdiction over a man or woman can only exist if the man or woman is a slave, i.e., property or res an object, in which case his or her disposition at law is no different than if he or he were a horse or other goods. See the Zong, Gregson v. Gilbert 99 ER. 3, 233 KB. 1783. In nature, in rem jurisdiction is exercised over men and women by their creator, exclusively. Governments can therefore gain only a fictional in rem jurisdiction over men by creating various legal devices personas for those men to assume limited control of, e.g., citizen, taxpayer, driver, etc. Since the device is legal fiction, a falsehood made true by force of law, this persona is in fact a legal object or res. Just as in theater, the persona person is separate from the man or woman playing the part, therefore, there may be artificial persons, but not artificial men, natural persons, but not natural men. American Law and Procedure, Volume 13, CHV, Section 65, pp 156–157. The word, person, defined. Gaius says, de juris division, the divisions of law immediately preceding his division of the law, then follows, de condition hominum, meaning the condition or status of men. In the Institutes, de jure personarum, precedes the expression, all art civil law relates either to persons, or to things, or to actions. The words persona and personae did not have the meaning in the Roman which attaches to homo, the individual, or a man in the English. It had peculiar reference to artificial beings, and the condition or status of individuals. Citations omitted, bold and italics emphasis added. In footnote 33, we get at the modern application and its implications. Quote, The word, person, in its primitive and natural sense, signifies the mask with which actors, who played dramatic pieces in Rome and Greece, covered their heads. These pieces were played in public places, and afterwards in such vast amphitheaters that it was impossible for a man to make himself heard by all the spectators and later by all judges. Recourse was had to art. The head of each actor was enveloped with a mask, the figure of which represented the part he was to play, and it was so contrived that the opening for the emission of his voice made the sounds clearer and more resounding, vox peronabat, when the name persona was given to the instrument or mask which facilitated the resounding of his legal voice. The name persona was afterwards applied to the part. 23 C. Waterman v. Mackenzie, 138 U.S. 252 1891. 22 C. Brigham v. U.S. 38 F. Sup. 625 D.C. Mass. 1941. Appeal dismissed 122 F.2 D. 792. Reported in Title 26 IRC 31, page 356. 21 C. Burnett v. Smith, S.W. 1007 1922 and Muir v. CIR, 182 F.2 D. 819 CA 4 1950. 20 C. Clues v. Jameson, 182 U.S. 461, 21 S. Court 845, 45 L. ed. 1183 1901. 19 C. The Constitution for the United States of America, Art. I. Section 10, 1789. No state shall pass any law impairing the obligation of contracts. 18 ID. At p. 11. Contract is alienable, whereas its creator's natural right of contract obviously is not. 25 The express trust nevertheless possesses, inter alia, the right to all enjoyments stemming from the contracts into which it enters, as well as all the obligations imposed under such contracts. The express trust possesses the ability to hold, own property, engage in business transactions, and incur liabilities including tax liabilities, as well as assume creditorship including secured party status like any other legal person. The trust corpus. The corpus is the body of the trust, i.e., the property being held in trust for the beneficiaries, the very subject matter of the declaration. It should be noted that virtually anything the 26th of may be held in trust. However, there are certain things which, given their innate traits recognized in law, make for better subject matter, so to speak. Initially, the legal minds who perfected the express trust in America did so to accommodate for the great obstacles in procuring special charters for corporations intended to deal in real estate, which trusts eventually came to be known as the Massachusetts Land Trusts. It was when those individuals came to realize the immense benefits of employing the trusts for the purpose of holding land, that they eventually expanded their utility to include the holding of personal property. These eventually came to be known as the Massachusetts Electric Companies. As an aside, when considering the presently hostile official attitude toward non-statutory trusts, what is interesting to note is that much of the express trust's perfection is attributed to Attorney General and later United States Secretary of State Richard Olney, 27. But the 6 Weiss'Sconcise Trustee Handbook. 27 C. John H. Sears, Declarations of Trust as Effective Substitutions for Incorporation, Section 1, page 4, 1911. Olney served as Attorney General in 1893-1895, U.S. Secretary of State in 1895-1897, and prior to that in the Massachusetts House of Representatives in 1874. 26. The thing held in trust is referred to as the trust res, the subject matter of the trust. 25. Man's right of contract is considered so fundamental that even under Roman law, in its system of domestic slavery, all men, citizen or not, with the exception of slaves, the only non-persons, retained this fundamental right jus gentium. It is understood to derive from a man's creator, and therefore is unalienable, even with his own consent waiver. Man's right of contract, logically, is held by him in trust to his creator as property which has been settled upon him, and thus can never be contracted away because such would invalidate the original contract itself. Which the actor had undertaken to play, because the face of the mask was adopted to the age and character of him who was considered as speaking, and sometimes it was his own portrait. It is in this last sense of personage, or of the part which an individual plays, that the word persona is employed in jurisprudence, in opposition to the word man, homo. When we speak of a person, we only consider the state of the man, the part he plays in society, abstractly, without considering the individual. 1 Bouv. Inst. Note 1. Bold and italics emphasis, and bracket information added. Logic follows that if the man plays no part in a society, then he has no personal attachment or obligation thereto. The trustees under a declaration of an express trust are only persons in the private sense because he is only a person once he has accepted the role offered to him by the settler. Private persons may also pursue constitutional protection as natural persons, citizens, within the meaning of Article 4, Section 2 of the Constitution, and may thereby claim entitlement to all the privileges and immunities of same. See generally Paul V. Virginia, 75 U.S. 168 1868. Even though, in today's economic situation the term citizen is presumed to signify the 14th Amendment citizen, the term cannot be applied to express trusts when administered properly. In contrast, corporations, as artificial persons, are citizens of the United States, within the meaning of the 14th Amendment per Santa Clara County v. Southern Pacific R. Co. 118 U.S. 394, 396 1886. fact that the express trusts were initially, primarily utilized for purposes of holding and handling real estate is very significant, especially to our present situation. The significance derives, in pertinent part, from the integral relationship between the law and the land. It is a